6.5 years after the explosion that killed 29 men in the Pike River mine, the decision to not prosecute the mine's CEO at the time, Peter Whitall, is to be contested in the Supreme Court. The law here is somewhat convoluted in the telling. When Peter Whittall's insurer paid $3.4 million to go to the victims' families in 2013, WorkSafe New Zealand dropped its charges against him. Whitall, who repeatedly declines invitations to be interviewed and doesn't even return our calls, had been facing 12 charges. In the end, he faced none. Sonya, Rockhouse, who lost her son Ben, and Anna Osborne, who lost her husband Milton, have argued the money was a stifling payment and the charges should have proceeded. Their lawyer is Nigel Hampton QC. Given this has gone through the High Court and the Appeal Court, I asked Nigel Hampton what grounds they're going to the Supreme Court on.
It's become increasingly narrowed as we've gone up through the levels of court. The one point that we are now taking to the court is, was the Court of Appeal wrong in saying that this was just a voluntary payment on the side, or are we correct in the argument for Anna and Sonya that this was indeed a bargain between Mr. Whitall on the one hand and WorkSafe on the other, and was it an unlawful bargain because part of the bargain was payment of $3.41 million, which in effect was to make the prosecution go away. We say that was a stifling and unlawful agreement, and that's the issue.
And once the $3.4 million was volunteered via Mr. Whitall, courtesy of his insurance company, the prosecution did go away, didn't it?
It did. We say, you know, it waddles like a bargain, it cracks like a bargain, it is a bargain.
Speaking as a representative of the families, their legal counsel, do you think that decision in the district court to not prosecute Peter Whitall was the correct one?
Well, it goes further back than the district court. It goes back to the decision made by the prosecution, that is WorkSafe, not to proceed further with the prosecution. Having chosen to bring a prosecution, and therefore the police having shut their file, and having chosen to bring a prosecution, and because of the time lapse, if they failed to bring it to fruition, people like Anna and Sonya couldn't bring a private prosecution. Having started out, they then made a wrong decision to, in effect, offer no evidence and say the charges should be dismissed. That's the wrongness. That's the target decision that we're taking to the Supreme Court.
And so that's WorkSafe. And in a sense, the poor district court judge, gosh, I wish I hadn't used that word, the district court judge found herself between a rock and a hard place. If no prosecution was being offered, there wasn't much she could do?
There was little options, effective, that she had. We did argue that she should have exercised an independent mind, but that is a very difficult proposition, and that's sort of fallen away. We're now just concentrated on the main proposition. In the High Court, the High Court judge said that in these circumstances a court could not review a prosecutor's decision. It was a discretion exercisable by the prosecutor and would not be interfered with by a court. In the Court of Appeal, we said that was wrong, that it could be interfered with. The Court of Appeal agreed, but then determined that this wasn't a bargain as such, but just a voluntary payment on the side, and therefore there was nothing wrong with it as such. And it's from that determination that we now move to the Supreme Court with the simple issue, with the Court of Appeal right or wrong in saying that.
And as you work your way to the Supreme Court, the fact remains that 29 people died in a workplace accident and no one has ever been prosecuted for that.
Yeah, that's correct. I mean, WorkSafe took up the cudgels for a start, then dropped it. The police, in the meantime, had dropped their prosecution. The families, because of the affliction of time, could no longer bring a private prosecution. So, therefore, no one held accountable.
Nigel Hampton QC talking to us earlier.